Now, in this video, we want to take a minute and talk about witnesses because our approach is we're going to be getting the case ready. We're going to be looking to take a plea offer. If there's, generally speaking, if there's anything we can do to get the client out on probation or minimize the jail time, it's most likely going to be in their best interest to do that. But in the meantime, we got to get the case ready and we have to prepare as if we're going to go to trial. So the first thing that we need to look at is what witnesses are we going to have. Now, first off, whoever's being accused of the crime, no offense, but you're not going to be the best witness. So one, we might not even let you testify. But two, if you're the one accused of a crime, you got to remember that your word is already under attack. So your word against the victim is not going to work out very well because you're stepping in there already behind the eight ball a little bit. So what would really help us is if there's other witnesses that happen to be present, they could testify for us. And it doesn't always happen, but sometimes we had other witnesses that were there and they can testify for us that you didn't do what you're accused of doing. Other times we can have witnesses that can testify and verify that you weren't there, you weren't where they accuse you of being, and it wasn't you. But we want to sit down early and get a handle on who all we might have available. And with some cases, there was nobody else around. It was just either the client by themselves or the client and the alleged victim, and so there's just not really any other fact witnesses we're gonna have to be able to use. Other times we do, but we need to make an evaluation of how good of witnesses these folks are gonna make. And so like if they got a drug or alcohol problem, they're not gonna be so good. If they're not very articulate, can't really explain themselves, again, that's not gonna be so good. And the other thing is we have to keep in mind that when we're using a witness, how they talk and what they can say in court is very, very different from how we speak and how we talk out in the real world. And one thing that folks don't realize is how much we say we know things or we know for a fact when really what we mean by that is we have made that conclusion based upon all these facts that we know. So out here you can say, well, I know Sally did it, or I know Sally would never do that, but you don't really know that. And you're not going to be allowed to say that in court. In court, you can only testify to what you actually observed. And the reason I bring that up is a lot of times we get folks to come in like, oh yeah, we got these 6 witnesses, it'll be great. And then we start doing some digging and none of those witnesses really saw anything that could help us. They have all this secondhand information that's good for out here in the real world. It's good for a conversation among your family and friends, but it's not going to help us in court. So we're going to be limited on what types of witnesses we can use. And then sometimes just luck of the draw, the witness that we have that's for us happens to be a drug addict or a long criminal history or that sort of thing. But again, it's just something that we want to get a handle on early so we can evaluate early, and then we can understand the risk that our client's facing and help them make the best decision that they can make.